What are the top questions about assault family member charges in Houston, Texas? We're going to answer those right now. Howdy, my name's Brian Foley. I'm the managing partner at Houston Criminal Defense Attorneys, PLLC, and we're going to be talking about assault family member today. The top questions, here they are. What is an assault family member charge? Well, it is a charge under Chapter 22 of the Penal Code. It's an assault charge, meaning that bodily injury has occurred. That means some kind of scratch, some kind of pain, not necessarily a mark, but oftentimes some type of visible mark. If that occurs to a family member, somebody that you've been dating or in an intimate relationship, or with somebody that you've been living with, then it can be called an assault family member case. And the real difference there relates to our next question, and that is, can a protective order evict me from my own home? The answer there is yes. In Houston, they call it a Magistrate's Order of Emergency Protection, or a MOEP. And typically those last for 61 to 91 days. 91 if you have like a deadly weapon that is used in it. That'd be a felony assault family member charge, maybe aggravated assault family member. But under a typical bodily injury family member case, you're gonna have a protective order that lasts for 61 days. This can kick you out of your own home. And it's something that we would need to address quickly with your case if you wanna move back into your home. If you want to have contact with your kids or contact with the victim again, then we've got to get that protective order lifted. We've also got to get your bond conditions lifted. In Houston, almost every case has a condition where you can't make any type of statement or communication to the victim. Now, they can text you, but you can't text them back. They could call you, you can't answer, you can't talk with them. That is typically what they're doing in these cases. And again, you won't even be able to move back into your own home. I get this question a lot. What if I'm paying the rent? Yeah, even if you're paying the rent, you can't move back in there if one of these orders is in place. We've got to get that lifted for you. So how do you fight these cases? Well, the first thing we do is look at all the evidence that the district attorney's office is going to provide to us under Article 3914 of the Code of Criminal Procedure. We're going to start fighting those MOEPs, those bond conditions, and seeing if we can get the judge to remove or reduce any of those conditions as we are evaluating the evidence. The whole process for one of these cases can take from 6 to 9 months, so it's not going to be something that happens really quickly. Another question we get a lot is, can I be prosecuted if the victim wants to drop the charges? Technically, the answer here is yes. You can still be charged with this offense in Texas, even if the victim or the person listed as the victim doesn't want you prosecuted. Even if they say they call the DA, they say they were lying about the incident, all that's going to happen at first is the case is going to get transferred to the Family Criminal Law Division, where a more experienced prosecutor is going to look over it, and they're going to do what they call evidence-based prosecution. Is there a mark that we can see? Is there another way to prove the case? Are there hearsay statements that can be admitted under an excited utterance exception? They're going to look at all these things and evaluate your case anyway, so you need a skilled lawyer on your side evaluating the case from your perspective. And then our last question, what is the punishment range for this? A Class A misdemeanor in Texas is what an assault family member is generally charged as. That's if you've just caused regular bodily injury. And a Class A misdemeanor is up to a year in jail and up to a $4,000 fine or probation for up to 2 years. But what we are going to be trying to do is minimizing that, or trying to get a type of probation that gets the case dismissed, a pretrial diversion, or some type of conditions for dismissal if we can't get your case dismissed outright because of the law or because of the facts are weak. We're going to try one of those different avenues. Thanks for tuning in. Remember to like and subscribe if you like what you saw today. Thank you.